Right. Hello, everybody, and welcome to MSUFCU's Financial Education Seminar Series. We appreciate you all joining us tonight, and we're excited that you're here with us virtually. These presentations were really created with you in mind, with the intention to give financial education on a number of different relatable topics to really help expand your knowledge and understanding of finances. Each one of our events will be hosted by a member of our financial education department and one of our partners. So, connecting you with just resources in our community. We have a number of diverse presentations planned for this year, and you can explore and register for them by visiting us at msufcu.org/events. Tonight's event is being recorded. If you want to rewatch or share this presentation, we welcome you to go to youtube.com/MSUFCU. Then you can select MSUFCU seminar series from the playlist options. And then tonight's recording will be available within 2 weeks. Okay. We will be pausing tonight throughout our session to address any questions. We do ask if you have questions, please submit those through the Q&A. Michelle has welcomed us to stop during the presentation to answer those questions if they're relevant to what we're talking about. If they're just more general questions, I may save some of those to the end. I'll be kind of moderating that. And then at that time, they'll be answered in the order they were received, okay? We'll also provide additional information and resources in the chat throughout our time together tonight. And then, like I said, we'll use the Q&A panel for our questions. So my name is Jessica Rubio. I'm one of our financial educators here at MSUFCU, and Will be facilitating this evening. If you do have any questions, concerns, or technology issues, please reach out to me privately in the chat, and I will be happy to help you with that. And again, if you have any questions for our partner, Michelle, with us tonight, please submit them into the Q&A. So tonight we have a very knowledgeable guest joining us to present on protecting your family with estate planning. So allow me to introduce our host, Michelle McRee, who is the owner of McRee Law, PLLC. Welcome, Michelle, and thank you so much for joining us.
Thank you, Jessica. Thank you so much for having me. This must be my third or fourth year doing these presentations for MSU Federal Credit Union, and I'm always happy to do it, to spend this hour kind of educating and informing the credit union's customers just on how important estate planning is. It is something that a lot of people don't realize some of the complexities and why we should be estate planning. So this is the perfect opportunity for all of you to get that information, build that foundation, ask any questions you might have. Like Jessica said, I'm happy to take questions as we go. That is welcomed. The more we interact with each other, the more interesting this is for everybody and the more information everybody's going to get. So please feel free, if you've got a question relevant to anything I'm talking about, to jump in into the Q&A box, and Jessica will forward that on to me. Full disclosure, I do have a bit of a dry, scratchy cough tonight, so you may see my big teacup come in and out of the screen. I apologize. I don't mean for that to be distracting, but I don't want to spend this night coughing at you. So I have my honey tea with me. The things we're going to talk about tonight are the things that I get asked about the most. And that is, number one, guardian nominations for minor children. Why are they important? Why should we have them? What happens without them? And what really is a guardian nomination? We're going to talk about probate. What is probate? What does it look like in Michigan? Some of the pitfalls of probate. And then the difference between a will and a trust. Those are two different estate planning tools that do very different things, and we're going to talk about that as well. If there's time, I want to briefly touch on incapacity planning. So that is healthcare powers of attorney and financial powers of attorney. And then, like I said, like Jessica said, there will be the Q&A at the end. So let's just go ahead and get started, starting with those guardian nominations. And hopefully some of you out there, this is relevant. This is going to be related to any of those viewers who have minor children. So I want to ask a question, and I know I'm throwing it out there to nobody responding directly, but it's a rhetorical question I just want you to think about. If you were lucky enough to get away for the night, whether it's a date night or just a night away from the home, and the children are at home with a babysitter, and God forbid something were to happen and you didn't make it home, what would happen to your minor children? Now, a lot of people I talk to think that they know the answer to this question. They believe and have every reason to believe that family members would step up and take care and custody of their children right away. But the reality is that's not necessarily how that happens. And the reason behind that is no one besides you and your child's other parent have legal authority to take full care and custody of your minor children. So if something happens to both of you, and you haven't done any estate planning, there is no one else, not even family members, who have that legal authority to step up and take care of your children. That's where there's the opportunity for police to get involved, for Child Protective Services to get involved. That opens the door to your children being removed from their home and placed into a foster care situation until a judge decides who's going to care for them. And this is what we want to avoid as parents. We don't want to see that happen. We don't want to see our child be subjected to the mercy of the court, to the mercy of a judge who's a complete stranger, and ultimately the one who would be making that decision as to who's going to raise your children. So as parents, we can take back control of the situation, and we can use guardian nominations to ensure that if anything happens to us, our children are not removed from the home and they're not thrown into the court system, and a judge is not the one who's going to decide who's going to raise them. We're able to put a plan in place that says who our children will be raised by and how we want them to be raised. So let's talk about guardian nominations. The most common place we see guardian nominations is in a will. Any well-written will for parents of minor children is going to have a provision in there that nominates who your first choice for guardians would be. Typically, it's good to have a backup list in order of priority, just in case your first choice is unable or unwilling to serve. And taking that a step further, you get to kind of decide what this is going to look like. So if you are nominating an individual who is married, you can decide if you're also nominating their spouse as co-guardians. If you do decide to do that, you can decide what happens if the two of them get divorced or if one of them passes away. Does it stay with those guardians? Do they both have authority to continue being guardians? Does only one have authority to continue being guardians? Does it go down to the next in order of priority? As the parents putting these guardian nominations in place, you get to decide what that looks like. Now, the one sort of nuance to naming guardians in a will is that it leaves a hole in your estate plan, a hole that a lot of estate planners don't think about and that a lot of parents don't even know to think about. And that hole is that if you've only named guardians in a will and you don't die, but you become incapacitated, it's almost like you didn't name guardians at all, because a will becomes a valid and enforceable document on your death. So if you're not deceased, there's no formal document that a court can rely on in appointing your guardians. That's a big hole in your estate plan. That risks the possibility of your child being subjected to the court system, being subjected to the judge deciding who's going to raise them. And how does a judge make that decision? It's done by various family members petitioning the court for guardianship. So any family member can step up and petition the court to be guardian of your child. And then it's basically like a custody hearing. The judge has to listen to all the petitioners and decide based on the information presented before him or her who's best suited. Who the judge picks might not be who you would have chosen. So by creating these guardian nominations, you're making sure that the judge knows who it is you want selected as guardian. Now at my law firm, McRee Law, and I know I didn't give an intro to my firm, I should have done that. My exclusive practice is estate planning. That's all I do. But sort of taking that one niche further is I have a large focus on planning for parents with minor children. So about 80% of my clients have minor children. So I'm really thinking about the things that a parent needs to do in an estate plan to make sure that they have dotted all the I's, crossed all the T's, and closed all the holes in their estate plan with respect to their minor children. So one thing I offer at my firm is called my kids coverage plan. And the kids coverage plan is not an estate plan in and of itself, but it is a supplement to a parent's estate plan to make sure that if anything happens to both parents, your children are going to be raised by who you want and the way you want, and there's not going to be any holes or cracks for anything to slip through.
So the first thing that the kids coverage plan has is the permanent guardian nominations. These mirror the guardian nominations in your will, but they're their own document. It's a freestanding document. So it is going to be valid on both death and incapacity. You've closed that hole. You've made sure the court has a document that they can rely on, regardless of whether you're deceased or simply incapacitated and unable to raise your children. The next document that the kids coverage plan has is temporary guardian nominations. I call these people the first responders. These are the people who live the closest and can get to your children the fastest in an emergency situation. They can show up, legal documentation in hand, and when authorities say, who has legal authority to stay with these children? These temporary guardians can say, we do. We have legal authority to stay with the children until the permanent guardian arrives. This closes that possibility of Child Protective Services having to get involved. This makes sure there is always someone there who can stay with your child. They don't have to be removed from the home. Sometimes the permanent guardian is the one that lives the closest and can get to your child the fastest, but it's good to have these temporary guardians named. It's good to have a few named as backups so that if for whatever reason your permanent guardian's not able to be contacted, or maybe they don't live nearby, or maybe they're traveling, you have this list of temporary guardians that can be contacted to make sure someone gets to the children right away. Confidential exclusion of guardian is not for everybody, but this is a really important tool for some families. This is where you have a family member who you would never want trying to get custody of your children, trying to get guardianship of your children. In this confidential exclusion, you name those individuals or that individual, and you say why you would never want them nominated. This document stays completely confidential unless that individual petitions the court. Once that individual petitions the court, this comes out of our toolbox, and it's a conversation of the parents put this exclusion together. Here's why they feel the way they felt. And if you continue your petition, the judge is going to be put on notice of all of these things. It's going to be filed with the court, become part of the public record. And that's typically enough to get those individuals to step back and not complicate your estate plan, but rather to let things happen the way you intended them to happen. So that's a great tool for some families. Instructions to guardian, that's a document that the parents work on together, laying out spiritual values, financial values, educational values. How do you feel about allowance? How do you feel about your child's first vehicle? What family members do you want to ensure your child continues to have a relationship with? This is where you can sort of create that roadmap for your guardian so that once they take over that important role of raising your children, they know what was important to you. They have that instruction manual to kind of guide them through raising your child. Instructions to caregiver is a sheet that identifies your temporary guardians. It's a great sheet to leave at the daycare, to leave at the school, to leave on the table when you go out and there's a babysitter, just so that if anything happens and you don't make it back, there's a list of the people to call right away who have legal authority to get with your children and stay with your children. That is the same goal behind the ID card. The ID card identifies your temporary guardians and their contact information. It's made to fit right behind your driver's license. And it says, if I'm in an accident, contact these individuals right away. They have instructions and authority regarding the care of my minor children. So just another way that we are trying to make sure that CPS has no opportunity to get involved, but instead the people who we've given legal authority are able to get to our children right away in an emergency. And then the last thing that the kids coverage plan includes, excuse me, is the healthcare information of each minor child. So this is just a document that's going to identify who their treaters are. Do they take any medications? Do they have any allergies? Any special health conditions that somebody caring for them needs to be aware of? We're going to make sure this is all documented in one place so that if somebody is taking over the care of your children, they're going to be privy to that important healthcare information. So that all together, that's the kids coverage plan. And like I said, it's not an estate plan in and of itself, but it's a great supplement to a parent's estate plan to make sure your kids are going to be raised by who you want in the way you want if anything happens to you. And then I just want to take a second to throw out there, if you have any questions related to guardian nominations, guardianship hearings, the kids' coverage plan, any of the things I just talked about in the first 5 minutes or so, now's a great opportunity to ask those questions. So I'm just going to give you guys 1 second and I'm going to take a sip of tea. Okay, I don't see anything coming in, but I can always jump back to it if we need to, so it's no problem. Let's move forward though. Now, if you have minor children, of course, it is absolute priority to plan for what happens to your children if anything happens to you. We also need to plan for what happens to our assets. And the goal there is a little bit different than if you don't have minor children and you're planning what happens to your assets. If you do have minor children, the goal is not to give your children some big windfall inheritance. The goal is to take the assets that you have and make sure you put some sort of plan in place that ensures that the financial burden will never fall on the guardians that you've nominated, and that your children have the financial resources they need to get to adulthood. If you don't have minor children and your beneficiaries are all adults, then maybe the goal is a little different. The goal there is more to pass that wealth to the next generation and give the people you love an inheritance. So it's a different perspective if you're a young adult with small children versus an older adult with adult children. The next thing we're going to talk about is probate. So I'm not sure if anybody here is familiar with probate or what sort of experiences you've had with the probate process, but I can tell you that I've never met anybody who has gone through the probate process in Michigan and enjoyed the experience. Michigan is just simply put, not a probate-friendly state. Some states are. In some states, you can go through probate relatively painlessly. Michigan is not one of those states, and I'm going to talk about why. But before I do, I want to make sure you have a good understanding of what probate is. So probate is the court process that assets titled in your name at the time you die have to go through to get out of your name and into the name of whoever's ultimately going to receive them. So the example I like to use is if during your lifetime, you want to give an asset that is titled in your name to someone else. So my house is titled in my name and I want to give it to Jessica. The only way I can transfer that asset out of my name and into Jessica's name is through my signature. If I'm deceased, excuse me, I can't sign my name to make that asset transfer. So that's where probate comes in. It goes through this detailed process laid out by Michigan state law to represent my estate and get all of those assets out of my name as a deceased person and into the name of the people who are ultimately going to receive them. Now, if you die without a will, at the end of that probate process, Michigan state law says who is going to get what from your estate. So if you do not have an estate plan, Michigan has one for you, and it's going to trickle those assets through your family tree. If you die with a will, where there's a will, there's a probate. Wills do not avoid probate. This is a common misconception. If the only estate planning tool you're using is a will, your estate is going to have to go through that probate process. But at the end of that probate process, the will is going to dictate who your beneficiaries are and who gets what. So at least by having a will in place, you're ensuring that your assets are going to go to who you want them to go to, but you're not going to be able to avoid that probate process. A few pitfalls of probate. Why do I say Michigan is not a probate-friendly state? Number one, probate is long. It takes 1.5 to 2 years for an estate to get through probate, and that's if everything is going well. Where anybody is contesting or challenging the administration of your estate, it's going to take even longer. Probate is expensive. It takes about 5% of the value of your estate to get your estate through probate. So think about everything that is in your estate, everything that you have an ownership interest in. Your money, cash securities, any other investment accounts, residences and other real estate, business interests, any of your personal property, the face value of your life insurance policies, any of your retirement assets like pensions or profit sharing, 401ks, IRAs, any jointly owned property, so any property you own with someone else, the value of that still goes into your estate. Any inheritances that you've received, and anything else that you have an interest in. These are the things that make up the value of your estate. So think about what your valued estate is and take 5% of that number right out of the pockets of your beneficiaries and into the pockets of someone else just because it has to go through the probate process. This is for things like court costs, filing fees, administrative fees, fees associated with liquidating and selling your property. And because probate is complicated and a lot of attorneys choose to bring on an attorney, that's 1.5 to 2 years, if not more, of attorney fees. So it is a large sum of money coming right out of your estate and going to someone else. The third major pitfall of probate is that it's public. It takes a lot of documents to be filed with the court to get your estate through the probate process. And all of these documents are part of the public record. So anybody can actually go in the courts and look up an inventory of what your estate contains. So everything that's in your estate and the value of those items. They can look up the names and contact information of your beneficiaries. Your will is part of the public record. So this document that you created to be private amongst your family is now filed in the court system and is part of the public record. And maybe, this invasion of privacy is of no concern to you because you're deceased, but also it's your beneficiary's privacy who's being invaded, the ones that are stuck going through this probate process in order to receive their inheritance. So keep that in mind, that it is a public proceeding if your estate has to go through probate. If you are a parent of minor children, there's a few other pitfalls of probate. So at the end of the probate process, whether you have a will or not, your assets are going to be distributed to your beneficiaries. If your beneficiaries or any of your beneficiaries are minors, the court is not going to allow them to receive their inheritance. The court doesn't allow minors to receive large sums of money. So in that instance, the court is going to put those minor beneficiaries into a conservatorship. The court is going to appoint a conservator to manage the child's money until they turn 18. If you haven't done any estate planning, we don't know who that conservator is going to be. It's going to be up to the judge to make that decision. The conservator is going to want to get paid for the work that they do on an annual basis. So that is more money coming out of your child's pockets and going into someone else's or grandchild's pockets, whatever the case may be. And then worst of all, when they are 18, they're considered adults under the law and the conservatorship ends. Whatever's left in that conservatorship account is distributed outright to that 18-year-old, no oversight, no control, to do whatever it is an 18-year-old does with large sums of money. A lot of parents and grandparents don't want to see that happen. But if the only estate planning tool you've used is a will, there's no way to avoid that. So keep that in mind. Now, I'm sure that some of you are thinking, well, what about assets that I've named a beneficiary on? How does that work? And that's where the 3 buckets come in. So the first bucket is jointly owned assets. The second second bucket is beneficiary designated assets. And the third bucket is probate assets. And I see a really good question come up, and I'm going to answer it as I explain this. So the first bucket, jointly owned assets, any assets that you own jointly with somebody else is going to avoid probate at your death because it's going to pass directly to that joint owner. And now they are going to be sole owner of that asset. A really good example of this typically is husband and wife own a house jointly. If something happens to one spouse, surviving spouse goes on, no need to probate their own home, they become sole owner. A little side note, and I see this happen all the time, if you are married and you share a marital home and you are both not on that title, you need to correct that. You both need to be on title as joint owners, because if something happens to the spouse that is holding title and the other spouse is not named in the deed, that spouse is going to have to go through some sort of a probate process for their own home. And we don't want to see that happen. So make sure your deed names both of you as joint owners. The nuance about assets avoiding probate jointly owned is that if something happens to both owners, husband and wife, something happens to them at the same time, now there's no surviving owner, that asset's going to fall into the probate bucket and have to go through probate. So just because something is jointly owned, it's not a foolproof estate planning method to ensure that it's going to avoid probate. There is a circumstance that could occur that would result in that asset going into probate. The next asset is beneficiary designated assets. So this is any asset that you're able to nominate a beneficiary. Our life insurance policies, our 401k, sometimes even bank accounts. Theoretically, anytime you have a beneficiary named on an asset, that asset's going to avoid probate because it's going to go directly to the beneficiary. And to answer that question that came up, yes, beneficiary designations trump anything in the will. So if a will says, I leave my life insurance policy to my spouse, but the beneficiary designation says that it goes to your sister, sister gets the life insurance policy. It is going to trump what is in the will. With beneficiary designations, it's also not a fail-proof way of estate planning to ensure that the asset never ends up in probate. For example, if you name a beneficiary and that beneficiary is deceased and you haven't named any backup beneficiaries, now there's no living beneficiary, that asset is going to pour into the probate bucket. If you've made a mistake that a lot of parents of minor children have made and you've named your minor child on a life insurance policy or a retirement account as either a beneficiary or a contingent backup beneficiary, you're throwing them into the probate bucket because there's going to have to be that conservatorship put in place. Again, the court's not going to allow that minor to receive that asset. They're the named beneficiary. Toss them into the probate bucket and set up that conservatorship. So where you think you've maybe put this plan into place that's going to avoid probate, even beneficiary designated assets can end up in that probate bucket. And coming off of a question I see pop up, it's kind of relevant to this beneficiary designated bucket, so I'm going to address it. And it's also a very popular phrase that a lot of people have heard, but they don't really know what it means. And that is the ladybird deed. What is a ladybird deed? A ladybird deed is basically a beneficiary designation deed. It's a deed that says my property is mine during my lifetime. I can do whatever I want with it. But when I die, it's going to pass automatically to my named beneficiary. A couple nuances here. Number one, first of all, we're one of only a few states that have them. And under the right set of facts, they're a really, really good tool. They're not always the right tool or the best tool, but they are a great tool to have under certain circumstances. One set of circumstances that makes it a less than ideal tool is if you have a home and you have multiple adult children and you all want them to receive the property. If you name them all as beneficiaries on the ladybird deed, you're locking them in as joint owners with rights of survivorship. And if they don't agree what to do with that property, they're going to the probate bucket and they're fighting it out in the probate court. So be really careful with that when you name multiple beneficiaries on a ladybird deed. Because I've seen it happen. I used to practice probate litigation. I've seen it happen where one sibling wants to live in the house, the other sibling wants to sell the house and split the sales proceeds, and the third sibling wants to rent the house out and make it an Airbnb. If they can't all decide what to do with that house, the only person who's going to be the decision maker is a judge. So not always the best tool if you have multiple beneficiaries, but we do have that tool. It is a beneficiary designation deed, and there are times when it can be a really useful estate planning tool. Now, anything that doesn't fall in jointly owned assets or beneficiary designated assets is going to fall in that probate bucket and have to be probated. Now is a good question if you guys have any questions about probate or the three buckets, the pitfalls of probate, anything that we just talked about. Okay, if you think of something, we can always jump back to it. So feel free to chime in if necessary. Okay, so if anything I said in the first 32 minutes, and I can't believe I've been talking that long, sounded like something you want to avoid. You don't want your family to go through that long, expensive, invasive probate process. You don't want to risk your children being thrown into a conservatorship or your 18-year-old or young adult children receiving a large sum of money before they might be financially responsible enough to receive it. If the only planning you've done is through jointly owned assets and beneficiary designated assets, and you realize that might not be the most solid planning tool to use, the good news is there is a planning tool that can solve all those problems and avoid everything that I just talked about. And that is the revocable living trust. Now, I've learned in doing this the last, 6, 7 years, that there's a lot of misconceptions about trust. We hear trust and we think the super wealthy, we think trust fund babies. We think that if you're not worth a certain amount of assets, then a trust isn't the right planning tool for you. That is not true. I tell people that if you have anybody or anything that you love, a trust is right for you. So what is a trust? A trust is nothing more than an agreement by you, with you, for your benefit during your lifetime and for the benefit of your beneficiaries after you're gone. The biggest thing that a trust does is it avoids probate for any of the assets that it holds. And what do I mean by that? How does a stack of paper hold assets? Well, when we create our trust, we give our trust a formal name. And to put assets into our trust, we have to retitle our assets out of our name and into the name of our trust. So think of your trust like a little red wagon. During your lifetime, you're going to take all of those assets in your name, put them in the name of the trust, and start filling up your wagon. Any asset you have that is beneficiary designated, you're going to designate it to your wagon. You're going to put everything you have into that trust wagon. While you are alive, you are the one pulling the wagon. You are called the trustee of the trust. You have full control to put assets in, take assets out, give assets away, sell assets, invest assets, whatever you want to do, you're the one pulling the wagon. And a lot of times we see married couples create one trust, so they're pulling that wagon together. Business as usual, operating as husband and wife to manage their assets. Now, what happens is when both trustees, or just if in the case of a solo, one trustee passes away, the trust says who's going to take over pulling that wagon. That person is called the successor trustee, the next trustee. That person is now holding that wagon handle, and they have full control to start distributing assets out of the wagon and to the beneficiaries according to the terms in the trust laid out by the creator of the trust. And they don't need the court's authority to do it. You're essentially handing them your pen and you're saying, here, you're holding the wagon handle. You have authority to sign your name and transfer these assets out of the trust and into the name of my beneficiaries. This is a totally private distribution of your assets within your family unit. No court involvement whatsoever. So that's the biggest thing the trust does, it avoids probate. But there's a lot of other benefits to a revocable living trust, especially if you have minor children. Having a trust allows you to say how and when your beneficiaries are going to receive their inheritance. So you're able to say, I want my trust split equally amongst my children. I want my successor trustee to make sure my children are financially supported using their trust share, but I don't want my trustee to give them any money to put in their pocket to spend how they want until age 25. They get half at 25 and they get the remainder at 30. And that's just an example. You can make that look like however you want to look whatever you want it to look like, but you're able to push out the distribution of inheritance to an age where you feel that they're financially responsible enough to receive it. And you can stagger it. If you don't want it to be some massive windfall, you're able to stagger it and break it up into however many distributions that you choose to, while at the same time ensuring that they're financially supported, but it's the trustee that is doing that financial supporting. Now, a really great benefit of the trust is where you have a guardian who needs access to the money to support your children. They have immediate access. They can get financial resources right away. Where the estate has to go through probate, that financial burden has to fall on the guardian until all of the funds are released at the end of that 1.5 to 2 year period. Your estate is essentially frozen during probate. So that can be a concern of some parents. They don't want to put that financial burden on their guardian. A trust is a great way to ensure that that never happens. Excuse me. Another benefit of a trust is that it allows you to sort of incentivize. For those of you that have really small children, I always tell clients, I have small children myself, we don't have the benefit of a crystal ball to know what types of adults our children are going to grow up to be or what paths they're going to take in life. but we may have some strong feelings about what we hope that they do, or what type of person we hope that they are. And we can use our trust to make sure that those things unfold. So for example, we can put in our trust, you're going to get your inheritance when you turn 25, but if you graduate from some sort of post-secondary education, you'll get an extra $10,000 early. So you can build in those types of incentives. If you wait to get married till after you've completed education, then you can use trust funds to pay for the wedding, that sort of thing. You can also use the trust to protect your children from themselves. So you can say, if my child, or I should say beneficiary, because it's not always the case where our children are beneficiaries, but you can say that if my beneficiary has a drug abuse problem or a mental health issue or joins a gang or a cult, anything where coming into a large sum of money could be detrimental to their well-being, my successor trustee can withhold distributions until that issue is resolved. So there's all these great tools that trusts offer us that wills just don't offer us. A trust is really a detailed instruction manual that you create telling your successor trustee how you want your estate to be distributed to your loved ones. So just taking a look, well, before I take a look at these benefits and go over those with you, I just want to see this question real quick.
Yeah, we did have a question come in, and I do think it's relatable, Michelle. So if you want, I can read it to you.
Yeah, that would be great.
And then we can go ahead and get that answered. So the question is, what are the main differences between 1, converting our current bank account to a family trust, or 2, keeping our bank account as is, but designating the family trust as the only beneficiary?
Okay, so I completely understand what you're asking in this question, but I want to clarify some of the way that it's phrased. So you don't convert your bank account into a trust. A trust is its own document. It's its own, it's its own agreement. And what you can do is change the name of the bank account, the title holder of the bank account, to the trust. So you can actually, your checks would say so-and-so's revocable living trust as opposed to just so-and-so. So it's a title change. You're not actually converting your account. This is a really good question, because this goes to what we call funding our trust, where we're actually filling our trust wagon with assets. And if you were to walk into your bank and say, I have a trust now, and I want to make sure my bank account is in my trust, they're going to say, great, we can do that for you, but you have to close the account and open a brand new one titled in the name of your trust. That's, no offense, Jessica, very annoying for people to do. Nobody wants to be closing accounts and opening new accounts. So there's a great alternative, and it's the second thing that you point out in your question. Keep the bank account titled in your name, as is, business as usual. Make that trust the beneficiary of the account. Some banks call it a beneficiary. Some banks call it a transfer on death recipient. Some banks call it a paid on death recipient, but they're all the same thing, just different terms of art. What we're doing is we're keeping your bank account yours during your lifetime, but making sure that after you're deceased, that it's going to pour into your trust wagon and be distributed according to the terms of your trust. Now, there's no right or wrong way. They're both perfectly acceptable ways to make sure that your bank account is in the trust. But that second option is the path of least resistance. It's a little bit easier to do. What I usually see people do is they take their savings account, and they do actually retitle their savings account into the name of the trust. And they take their checking account and they leave it in their individual name, and they just put that transfer on death recipient or that beneficiary on the account. So hopefully that answered your question. If not, please follow up. I want to make sure everyone gets all the information that they're looking for.
Michelle, I do have a quick follow-up question to that.
Sure.
Excuse me. So if someone did have multiple checking accounts, let's say at multiple financial institutions, right? If they were, can they designate their trust on all of those different accounts? So, if they have a credit union account here, maybe at another credit union, at a bank over here. So if they designate that trust to all of those accounts, then it's all going to be set up the same way, instead of going into all those different financial institutions and having to retitle and close out and open new accounts.
So you'd have to do each account individually into the trust, one way or the other. And it doesn't matter how many different banks you have, how many different accounts you have to go through that process for each account number. So with each account that has its own account number, regardless of what entity holds that account, you have to either change title to the name of the trust, or you have to make the beneficiary the trust. Now, what's going to happen is, so we're loading up our wagon during our lifetime. So there's some legwork involved in taking all of our bank accounts and stacking them up inside our wagon. But what's going to happen after you're gone is your successor trustee is going to empty out all of those accounts and combine them into one trust account in one bank. So whatever bank they decide to use, all of those are going to be brought under one umbrella and combined. That doesn't happen till after you're deceased and your successor trustee is gathering up assets to distribute them. So did that answer your question?
Oh yeah, absolutely. Thank you.
Okay,
That's
yeah.
just, I didn't, I think from the lens of being member facing and thinking about people coming in, and there are some people that like to house all of their accounts at one financial institution. There are other people that like to share them or spread them amongst different financial institutions. So, for people listening and attending tonight, knowing like they would have to go into each financial institution
Yes.
to designate that beneficiary as the trust. And then I'm glad that you made that point of when something happens to them, then that trustee will then come in and put everything in one account in the trust name. So thank you.
Yep, and it's really crucial, absolutely crucial, that you go through this process with each of your assets and you get them in your trust wagon one way or the other. And there's different ways that we do it for different types of assets. I know it, at least at my firm, I provide a set of instructions to clients so they know what they need to do. But if you create a trust and you never put any assets in it, so you don't retitle any assets or change any beneficiary designations, that trust is nothing more than the most expensive stack of paper you've ever had. It can't govern assets that it doesn't hold. So really, really important to do that. And I make a big effort at my firm and in my practice to ensure that my clients have done that, because without that, the services I've provided them are almost useless. Okay, so let's go over these benefits of a trust. Avoids probate at death. We talked about that. Prevents court control of assets. Oh, sorry, I'm trying to, move things around and I'm clicking the screen. I'm trying to read everything. Prevents court control of assets at incapacity. Assets and trust are managed by your successor trustee. So anything you've put in your trust wagon during your lifetime, if you become incapacitated and can no longer manage those assets, your successor trustee does take over the management of those assets, but in a different capacity than if you were deceased. If you are alive and incapacitated, their role is to manage those benefits for your best interests, for your well-being, not to start handing things out to your beneficiaries. So their role is different. There is instructions in the trust related to how they are to do that in the event of your incapacity. But the good thing about it is it avoids you having to have a conservatorship put in place over any of the assets that are in your trust. You've given somebody the authority to act on your behalf with respect to those assets. Brings all of your assets together under one plan. This is really, really important, because when I first meet with clients, oftentimes they have all sorts of assets all over the place. They've got all sorts of retirement accounts that they've started at various jobs. They've got a bunch of life insurance policies that they've acquired from here and there. They've got different bank accounts, and when married couples come together and they double everything, and now they've got a lot of stuff out there, and it's a little bit of an exercise to itemize those things and figure out where everything is. Once you create your trust, you're going through this process of figuring out what we have, where it all is, and then bringing it together under one plan as we put it in that wagon. So it really helps with financial organization to go through this process. Quicker distribution of assets to beneficiaries, not on the state's timeline or the court's schedule. Provides maximum privacy. Nothing needs to be filed with the court. Trusts are never filed anywhere unless they're being challenged or contested, but that's a sub issue that we're not going to get into too much. But when you create a trust, that is a private document for you and whoever you want access to it. You don't have to file that publicly anywhere. Assets can remain in trust until you want your beneficiaries to inherit. So that's, where we talked about pushing out to those ages that we want our beneficiaries to receive their inheritance, or even staggering it so that they don't get everything all at once.
can plan for estate taxes. We're not going to get too much into estate taxes today, but I will tell you it's not a concern for most people. Actually, I've never met anybody it's a concern for, because the federal estate tax exemption rate is $12.9 million per person. So you can die and pass up to $12.9 million worth of assets on to whoever you want without there being any sort of federal estate tax liability. So a non-issue for most people. There is no Michigan state estate tax. So any property in Michigan is not going to be taxed an estate tax at your death. Now, if you have property in other states, there are 17 states that do have an estate tax. So it's worth looking into whether or not states that hold some of your other property have an estate tax or not on the state level. And there is no inheritance tax in Michigan either. So just a little side note, your beneficiaries do not have to pay an inheritance tax for receiving an inheritance from you. Now, in the event that you do owe a federal estate tax, if you've got over $12.9 million in assets, there are some advanced estate planning tools that we can use. And I'm happy to have that conversation with any of you if that is a concern. But right now, it's just not a concern for most people. That $12.9 million is going to sunset in 2025. And in 2026, there's going to be some new legislation that lays out the federal estate tax exemption. We don't know what it's going to be. And with this being an election year, it's really up in the air. Things could go drastically one way or drastically the other. But what they're predicting is that that federal estate tax exemption rate is going to still be around $5 million adjusted for inflation. So between $5 and $7 million per person. So still not a concern for most people. But like I said, if it ever is a concern, there are tools that we can use to minimize the amount of taxes that your estate pays. Okay, can be changed or canceled at any time, fully revocable and amendable while you are living or while one spouse is still living. Very difficult to contest. Wills are not difficult to contest. Wills are actually quite easy to contest because of a concept in the law called heir at law. So heir at law means there are people in your family tree that can come out of the woodwork and say, oops, so-and-so forgot to put me in their will, but I'm an heir at law, so I would like to take one of the elections that I'm allowed to take under Michigan state law. That happens, it can happen, it does happen, and it typically ends up in a disastrous probate litigation. Trusts are not that easy to contest. If you are not named a beneficiary in a trust, you're not going to be successful at getting anything from the trust. Trusts don't care about heir at law. Trusts care about named beneficiaries. So they are really great documents if you have complex family issues and you don't want anybody challenging your estate. Prevents court control of minors' inheritances, no need for a conservatorship, and then can protect dependents with special needs and those who rely on government aid. That's another sub-issue, but just know that if you have a beneficiary who receives Social Security, disability, or Medicaid, and you want to be able to leave them an inheritance, but you don't want to risk them losing the eligibility for their benefits, there are tools that we can use to allow them to receive an inheritance, but protect their eligibility. So these are all of the main benefits of a trust, with many, many, many more that we could go all night talking about, but trusts are really, really great tools. Now, people always ask me, what's the catch? All you're doing is saying how wonderful a trust is, but what's the catch? Well, there really isn't a catch. The first, I guess, maybe catch is that trusts are more expensive to prepare on the front end than a will. It's the difference between a 10-page document and a 60-page document. Trusts are so much more detailed and solid compared to a will, and that's reflected in the preparation cost. The other sort of downside is the legwork that comes with creating a trust. You have to go through that process of filling your trust wagon. Assets do not get into the trust on their own. You have to actually fill out forms, sign documents, talk to your bank, talk to your life insurance policy holders, talk to your retirement account holders. You have to go through this process to get property into your trust. So that legwork is a little bit of a downside. Other than that, no downside to a revocable living trust. Okay, how are we doing on time? Oh gosh, I better speed it up. So this is just really quick. The difference between wills and trusts. You can see trusts avoid probate, wills do not. Trusts are private, wills are not. You can protect your assets for your beneficiary and provide for distributions over time. Wills come with significant attorney fees and delays upon your death during that probate process, and there is no asset protection. Your beneficiaries are getting distributed their assets outright at the end of that probate process. All right. The next, oh gosh, I am scrolling this thing the wrong way. Okay. Next thing I'm just going to talk on really quickly, powers of attorney. So when I talk about estate plans, I'm not just talking about a will or a trust. That is the first thing you decide. Do I want a will-based estate plan or a trust-based estate plan? But from there, you have to create this comprehensive estate plan that ensures you're covered in both death and incapacity. And with respect to incapacity, that's where these powers of attorney come in. So healthcare power of attorney allows you to nominate who you want making healthcare decisions for you if you're unable to. Financial power of attorney allows you to nominate who you want in charge of your finances if something happens and you're unable to manage your finances on your own. Without these documents, if you become incapacitated, you need a conservatorship and a guardianship put in place. So you and your family are stuck in the probate courts with guardianship and conservatorship hearings. Now, a lot of people think, well, why would I need these documents if I'm married? My spouse can do those things. And that's actually not true. With the healthcare power of attorney, it's all next of kin. So your spouse does not get priority. I don't know if any of you are familiar with the Terry Schiavo case out of Florida back in the early 2000s, but she was a young, I think she was 26-year-old woman who became incapacitated and was in a vegetative state. She did not have any powers of attorney in place. Her husband wanted to take her off life support. He knew she would have never wanted to live like that. Her parents did not want to take her off life support. They did not want to give up hope that their daughter would recover. For 10 years, she remained in that vegetative state. Thousands and thousands of court filings arguing between the husband and the parents who had the right to make her decisions. Ultimately, it was the husband who was appointed her guardian and got to make that decision. But that was so much undue stress and pain on not only her, but on her family, could have been avoided with a simple healthcare power of attorney document. Incapacity does not come with old age. You can become incapacitated walking down the street. So these are absolutely crucial documents to have in your estate plan. With the financial power of attorney, nobody but you has authority to manage assets that are in your name and your name alone. So yes, where you create a revocable living trust, any assets you put in your trust wagon, your successor trustee will be able to manage in the event of your incapacity. But we don't put our whole life in the trust wagon. We have bills, we have creditors, we have utilities, we have mortgages. We have all these things that still need to be taken care of if something happens to us and we can't do it on our own. That's where your general financial power of attorney comes in. So really important to have these documents in place just to complete your estate plan. Any questions about anything so far? We doing good? Okay. I want to wrap this up just by, and I'm not going to go over this last slide. I'm going to just skip to this. Just giving you guys an idea about how I help my clients get started with estate planning if it's something that they feel like they're ready to do. The first step is an initial consultation where we sit down and we look very specifically at your assets, your family, your goals, your objectives. And I spend quite a bit of time educating you on what type of planning might make the most sense, some things you might want to consider so that you can make a really informed and empowered decision about what your estate plan is going to look like. That's the goal of that initial consultation. And to anybody attending the seminar, that consultation is complimentary. There's no cost for it. So please, if it's something that you're interested in, take advantage of that. I offer in-home consultations. So I travel to my clients and I also offer Zoom consultations. So please feel free to reach out to me if that's something that you would like to get scheduled. From there, we actually design your estate plan. I walk you through a design process. I take all of that information and I put it into an outline for you. You get a couple weeks to work with that outline just to really clearly visualize your estate plan and make sure that everything is how you want it. And that's what I'll actually use to draft once you get that back to me. From date of design to date of signing is about 4 weeks. And at the end of that 4 weeks, you have a fully implemented estate plan. We meet for a signing and we go through the process of getting all those documents formalized and finalized and implemented. So I try to make it very easy for clients, very educational, very involved. And it's just a great peace of mind once you've completed your estate planning. And I guess, I only have a couple more minutes. I'll just jump back to this slide really quickly because it is kind of important to think about some of these things. These are some of the top 10 myths and misconceptions, and this just takes a few minutes. We'll go over it quickly. Estate planning is only for people of a certain age. That is not true. It doesn't matter if you are a young adult or a senior citizen. If you have anything or anybody you love, you should be estate planning. Parents of young adults, if you've got 18, 19, 20-year-olds that still very much depend on you, you should think about having financial and healthcare powers of attorney in place, having them nominate you as their agent so that you can still be there and be involved if anything happens to them and if they need you. Otherwise, your hands are pretty much tied now that they're adults. Estate planning is only for people in a certain income bracket. Also not true. It doesn't matter how much or how little you think you have, unless you want the court to decide where all of that goes. An estate plan is so important to have in place. Estate planning is only for people who have kids. That's certainly not true. Anybody who has people that they want to pass the wealth on to the next generation should have an estate plan. But if you do have minor children, estate planning is exponentially important because we need to think about what's going to happen to them if anything happens to you. My family gets along really well. They'll figure it out after I'm gone. I hear this all the time. People tell me till they're blue in the face, their family never fights. Don't put them in a position where fights could start. Death and money make people do crazy things. And by doing the planning so that they don't have to, you are really, truly giving them a gift and giving them nothing to fight about so they can continue getting along really well. Estate planning is only concerned with my death, and I'm not ready to think about that. That is very valid. These are hard, heavy conversations. But once it's too late, it's too late. So to do them now, while death is not knocking on your door, it's more of just planning and being prepared. And, we try and keep it light while, being sensitive to the fact that it is a heavy topic. But like I said, having it done is a huge, huge peace of mind. I had a will done 10 years ago, and that's good enough. It may be, but, life changes, assets change, the law changes. It's worth having these documents reviewed. I encourage reviews every 3 to 5 years. If you haven't taken a look at your documents in a while, it might be a good time to pull them out and take a look at them, see what's changed and what updates might need to be made. I had a will done when I was living in Texas, and that's enough. Most of these documents are state specific. They're governed by state law. So it's really important that if you have documents from another state, that you have them reviewed by a Michigan attorney so that you can ensure that they're going to be valid in Michigan. And that's vice versa. If you create documents in Michigan and you move to another state, you should have an attorney in that state review those documents. My buddy who handles medical malpractice cases did my will, and that's good enough. This one gets me because, I always tell people, we never know as much law as we do the day we walk out of the bar exam. And it really is kind of downhill from there because we pick our area that we want to focus on, and it's impossible to keep up with everything. So it's really important that if you decide to have an estate plan put in place by an attorney, that you pick an attorney that practices estate planning. Estate planning is ever changing, ever evolving. And if you want the absolute best planning done with the most up-to-date planning techniques and tools, you're going to want to make sure you're using an estate planner versus a general practitioner or a criminal attorney, medical malpractice attorney. I went online and downloaded a do-it-yourself will. This is, if you get nothing else out of this presentation tonight, please don't do this. You have no idea who created those documents. You don't even know if they were attorneys. You don't know if they are valid in your state or they meet all the requirements of your state law. And you might not necessarily understand all of the nuances to the boxes you're filling in. So you could make inadvertent mistakes in your estate plan that you didn't intend to make. These conversations are worth having with an attorney because these documents are so, so crucial. And when you're gone, this is all your family has to depend on. So make sure that they're done well. It really is a you get what you pay for thing. And if you get the cheapest version online, you're certainly not getting the best tools that you could get. And then I have a will. That's the only document I need to protect my family. Again, just coming back to this comprehensive estate plan concept, this concept that you want to have all the documents you need to be covered in death and incapacity. So that was just a little bit about that. And the last thing I want to say, and then I promise I'm done, is that McRee Law, all of our estate planning is done at a flat fee, a package price that you pick where you're comfortable depending on what kind of plan you want and what kind of documents do you want to include. I never bill my clients hourly for anything. So you're going to know coming into it exactly what the cost of your estate plan is going to be. It does vary, but I will say the average cost of a trust-based estate plan is about $2,500, just to give you guys a price point as you're kind of figuring out what is this type of service going to cost. So with that being said, that's all I have. So I'm not sure if any questions came up, but I'm happy to take any. Otherwise, if you'd like to reach out to me, please, my email address, michelle@mcree-law.com. Send me an email. You can also call me. It's 810-515-8888. So please just take advantage. I would love to meet you, work with you, and help you get an estate plan in place.
Thank you, Michelle. And to all of our attendees, I did put all of your contact information, your website, all of that in the chat for them with hyperlinks. So please feel free to click on those. Michelle, we want to thank you for your presentation this evening. That was super informative. Just so everybody knows, the recording from tonight's event, again, will be posted on our YouTube channel. So if there's something you want to go back and rewatch or re-listen to, that is going to be on our MSUFCU YouTube channel and the seminar series playlist. And like I said, it'll be available in about 2 weeks from today's date. So if there are any of you that are logged on that don't plan to stay for the Q&A session that we have coming up, I invite you to take the survey that will automatically open the event after, the survey will automatically open after you, after the event closes tonight. And so we welcome your feedback. And additionally, don't forget to join us at some of our upcoming sessions. We do have a couple of webinars coming up. One is for preparing for homeownership on Tuesday, February 13th. And then we have another one, raising children with financial literacy, on February 22nd. And so remember, by attending a qualifying live session, it automatically enters you into our monthly drawing to win a $50 Visa gift card. To learn more about that, you can visit our website at msufcu.org. With that, I am going to stop recording, and then we will finish answering any questions that have been submitted in the Q&A. And again, we'll be answering those in the order they've been received.